This is the Wizard News. The stench of smoked pot does not give a police officer the right to search an adult's car without a warrant, according to a new ruling from the Illinois Supreme Court. The searches were allowed when marijuana was illegal in the state. In a 6-0 opinion issued on September 19, 2024, justices say that changed when it became legal for adults in Illinois to use cannabis. Since January 1, 2020, the use and possession of cannabis is presumptively lawful, subject to certain restrictions, Justice Scott Neville wrote in deciding the case, The People versus Redmond. We hold that the odor of burnt cannabis alone is insufficient to provide probable cause for police officers to perform a warrantless search of a vehicle. Still unresolved is how far police can go if they smell raw cannabis, in potential breach of a state law that requires cannabis to be stored in an odorless container when a car is moving. The ruling resolves conflicting lower court opinions dealing with the smell of burnt cannabis and clarifies when law enforcement can conduct the search when they catch a whiff that indicates prior use of pot. A police officer may legally conduct a warrantless search if a car reeks of pot and other factors are at play. Other factors at play were not sufficient reason in the case before the state's high court, which saw Illinois State Police Officer Hayden Combs search Ryan Redmond's car in June 2021. The totality of the facts and circumstances known to Officer Combs did not provide probable cause to search Redmond's vehicle, the opinion reads. Combs stopped Redmond for driving 73 miles per hour on Interstate 80, where the speed limit was 70 miles per hour, and for not having his license plate properly secured. When Redmond pulled over, Combs said he smelled burnt cannabis. The state argued that the aroma, coupled with Redmond obfuscating about where he lived and that the incident occurred as Redmond was driving from Des Moines to Chicago on what Combs called a known drug corridor between two cities, justified his search of Redmond's car. During the search, Combs found a gram of cannabis in a plastic bag in the car's center console. Redmond was charged with unlawful possession of cannabis and unlawful possession of cannabis by a driver. The Illinois Supreme Court ruling opposed a trial court order that the marijuana Combs seized during the search cannot be used and that any evidence from the warrantless car search must be suppressed. The state's high court noted that Redmond did not hesitate to pull over or comply with the officer and that he admitted he saw no signs of impairment when he spoke to Redmond. The officer did not recall Redmond himself smelling like pot and there were not other signs of marijuana in plain sight, like smoke or paraphernalia, loose or unpackaged cannabis, or the odor of raw cannabis coming from the vehicle. The court found that there was no sign that Redmond was driving impaired, and Combs did not find any obvious evidence that he had smoked while driving. Therefore, the search Combs conducted was unreasonable and unlawful. The justices said the test for determining whether there's probable cause to search a vehicle without a warrant is comparable to how law enforcement should handle situations when they smell alcohol in a car. Like a pot, they wrote, alcohol is lawful in some circumstances but illegal in others, including prohibitions against drinking while driving, driving with a blood alcohol concentration of 0.08 or more, and driving with an open container of liquor. An officer may have probable cause to search a car if a driver fails a field sobriety test, if a driver stalls to pull over or tosses something out the window, or if police see a liquor, beer, or wine bottle on a car seat. But case law holds the aroma of alcohol alone is not enough to justify searching a car without a warrant. According to the American Civil Liberties Union of Illinois, in a friend of the court brief, such vehicle searches, typically following pretextual traffic stops, disproportionately burden Black and Latino drivers who are likewise targeted for disparate enforcement of cannabis laws. Under Illinois law, drivers and passengers cannot use pot when a car is in motion, and no driver may use cannabis within the passenger area of any motor vehicle upon a highway in this state. Cannabis must be transported and stored in a secure, sealed, odor-proof, and child-resistant container that is reasonably inaccessible while the vehicle is moving. Source: WTTW, September 19th, 2024.